Michael Popok, Legal AF. Fani Willis, Fulton County DA, says not so fast with stopping the prosecution of Donald Trump in Georgia by the Georgia Court of Appeals. She has filed a motion to dismiss on its face the appeal right now to the Court of Appeals. She has filed it arguing that because the entire premise and basis for Donald Trump's appeal of Judge McAfee's, the trial judge's decision that she should not be disqualified from the case, is based on his factual findings. And because those factual findings of that trial judge and all trial judges in Georgia and really in every other state have to be given tremendous deference by the appellate court, which cannot, under Georgia law, substitute their own findings, their own judgment for that of the trial judge. If you throw out all of the basis of the appeal for Donald Trump, which is based entirely on attacking the factual findings, Fani Willis argues you can't attack the factual findings, appellate court. You know the law in Georgia. I'm going to read to you from the motion and from the law. But she's instructing the Court of Appeals that they got it wrong. They should never have granted this appeal. That's why she framed it as a motion to dismiss an improvidently granted appeal. And improvidently granted means it should not have been done. It was done inappropriately and improperly by the appellate court. And she's arguing that since this particular appeal is entirely premised on the factual findings made and sifted through by the trier of fact, the trial judge, Judge McAfee. And since they can't substitute as an appellate bench, they can't act as a supra trial court to substitute their judgment for his, they cannot reverse the decision and they cannot grant the appeal and disqualify Fani Willis. So her argument is we don't have to wait around for the actual briefing of the appeal on the merits. We don't have to wait around till October for a potential oral argument or March of 2025 for a potential ruling. Dismiss the appeal now on procedural grounds because the very basis, the very linchpin, right, should be pulled out from under Donald Trump because you could never, under the circumstances here, you could never undercut or undermine or reverse the factual findings made by the trial court judge. It would be, that trial judge has broad discretion given to it by the appellate court all the way up to the Georgia Supreme Court. And the appellate court cannot be a super trial court and come up with its own reasoning, listening or reviewing the record. And since they can't do that, they never can reach the fundamental legal arguments or the fundamental legal premise for the motion that Fani Willis should be disqualified because she had some sort of financial interest in the outcome of the case, that she had some sort of improper appearance of impropriety relationship with one of her underlings or somebody that worked with her on her prosecution team, or that she committed what Georgia calls forensic misconduct because she gave a speech at a black church on Martin Luther King Jr. weekend and made some references to the case. The trial judge already developed those facts, and Georgia law does not allow a redo by the appellate court. Let me read to you from the actual opinion so you know what's happening here. And if she's successful on this, which will be separately briefed by all the parties and heard by this same Court of Appeals, this three-judge panel of the Court of Appeals, or ultimately by an en banc, the entirety of the Court of Appeals, if she wins, this case is over and it gets returned to Judge McAfee with Fani Willis, the newly elected or reelected, or will be reelected Georgia, thumbs up on that, Georgia Fulton County District Attorney. She will be presiding over, she will be prosecuting this case with Judge McAfee as well. So here's where we are. We got a motion to appeal. This is what they say in their opening on page 2. As both this court and the Supreme Court, meaning the Georgia Supreme Court, have repeatedly held, Georgia appellate courts will not disturb a trial court's factual findings on disputed issues outside of certain very rare circumstances. In other words, it has to be flatly incorrect, clearly erroneous. And there is no argument in Trump's briefs and those of the other co-conspirator defendants that appealed that he made a clearly erroneous statement of law. Finding of fact. They're attacking the law. They don't like the outcome. But in order to get there, they got to attack the factual record developed. And there is what Fani Willis tells the court and reminds the Court of Appeals. They have to give great deference to the trial court level. Or as they say on page 2, when a trial court makes determinations concerning matters of credibility or evidentiary weight of the evidence being presented, the testimony being presented, reviewing courts will not disturb those determinations unless they are flatly incorrect. They contrast that with conclusions of law. What they say is that the appellate courts owe no deference to a trial court's application of law to the facts, but they owe substantial deference to the way in which the trial court assessed the credibility of witnesses and found the relevant facts. To that end, the appellate court must accept the factual findings of the trial court unless they are clearly erroneous, and must view the evidentiary record in the light most favorable to the findings and judgment of the trial court. Again, we don't use the appellate court to do a do-over. And so that is the fundamental argument. You got facts and you got law. And if the facts have to be accepted as true, there's no way the appellate court could disturb and reverse the finding by Judge McAfee, the trial judge, that there was no inappropriate relationship, no inappropriate financial dealings, no forensic misconduct, and no basis to disqualify Fani Willis. And as it related to the relationship, they also said that the remedy that was created by Judge McAfee, which is that Fani Willis basically fire Nathan Wade, the person that worked with her on her prosecution team, to solve the appearance of impropriety well before any jury has been selected in the case, so there can't be any taint to the jury, it was sufficient. And then they go through in the 17 pages that they filed in talking about how the judge sifted through the trial testimony. Crediting the trial testimony of Fani Willis ultimately, and destroying the lead witness, if you recall, or I'll tell this audience now, the lead witness for Donald Trump and for Mike Roman and the others was Terrence Bradley, the star witness, somebody who used to apparently work with Nathan Wade, the lawyer Fani Willis had a relationship with somewhere, and who the lawyer, Ashley Merchant, for Mike Roman, argued was going to blow the lid wide open and tell the court on sworn testimony that the relationship between Fani and Nathan Wade started much earlier than they had told the court that it did. In other words, that they had perjured themselves in front of the court, except after the judge, who's the only one that can make this determination, and not the appellate court, after hearing the testimony of Terrence Bradley, this is how the brief puts it. Appellant star witness attorney Terrence Bradley was such an utter cipher of either credibility or useful information that the trial court felt compelled to discard his testimony in its entirety from the court. The court finds itself unable to place any stock in the testimony of Terrence Bradley. His inconsistencies, demeanor, and generally non-responsive answers left far too brittle a foundation upon which to build any conclusions. And that's the trial judge. And the appellate court is stuck with that particular set of findings. They then go on to talk about, at the bottom of page 5, that this is another factual finding of the trial judge that the Fulton County DA argues to the Court of Appeals can't be disturbed. And if it can't be disturbed and it has to be accepted as true, there is no proper grounds for appeal. And it should be dismissed as of right now. This is what they say at the bottom of page 5 in their brief. And most importantly, even when the trial court, considered everything proffered, every piece of evidence that was introduced, and cast a critical eye at the testimony from the district attorney. In other words, he didn't go easy on Fani Willis and her testimony. But even with that critical eye on her testimony, the court still found that appellants lacked support for claims of a material, personal, or financial stake in the present case, which is one of their major grounds, that somehow Fani Willis was benefiting from continuing to prosecute Donald Trump. And this is what the court said, that they remind the appellate court. Simply put, the defendants have not presented sufficient evidence indicating that the expenses were not roughly divided evenly, or that the district attorney was or currently remains greatly and pecuniarily interested in this prosecution. In other words, them going away, Fani Willis, Nathan Wade, on some sort of little holiday weekend in Napa Valley or wine tasting or going on a cruise, and he used maybe some of the money that he made from being a prosecutor, doesn't mean she's financially interested in the case. Like, in other words, she's not prosecuting Donald Trump because she wants to sip wine with Nathan Wade in Napa Valley. Get it? But they go on. At the end, they basically say on page 7, appellants were even less successful with their suggestion that the district attorney might have initiated the case solely due to a personal interest, or that she might be improperly prolonging the case, with the trial court finding that the record indicated precisely the opposite to be true. Again, a factual finding that Fani Willis is telling the Court of Appeals they have to accept as true. And if they accept all of these facts as true, as developed by Judge McAfee, there is no appeal. We don't have to get through the substantive arguments on appeal. We certainly don't have to wait until March of 2025 at the latest to figure out whether there's going to be a trial of Donald Trump in Georgia. And that's the argument. And so finally, as to the forensic misconduct, on page 10, Fani Willis says, the only argument for forensic misconduct, which is a term of art in Georgia, which has to do with things that the prosecutor does outside of the case itself that may indicate a bias or make an appearance of impropriety. And they said the only thing was some comments made at the church, but they said the trial court already sifted through that evidence, listened to that testimony, listened to that argument, and made its factual findings, which are not clearly erroneous and should not be disturbed and have to be given great deference under Georgia law. This is what the brief says. The motion says on page 10. As a factual matter, the trial court found that the district attorney's public comments concerned either the office's conviction rates, the charges in the indictment, the procedural posture of the case, the need for or importance of the investigation, or personal anecdotes. The only statements that the trial court examined in greater detail concerned a speech given by the district attorney on January 14th, 2024. That's the Martin Luther King Jr. speech at the Black Church. The trial court concluded that the speech did not cross the line because it failed to name any defendant, it did not disclose sensitive or confidential evidence, and it did not address the merits of the indicted offenses to move the trial to the court of public opinion. With these findings as to the speech, as well as the district attorney's testimony, the appellants cannot supply this court with any factual basis for reversal. And for these grounds, this is the last page, page 12, for the above reasons, the state of Georgia submits this honorable court should grant this motion to dismiss the interlocutory appeal as improvidently granted. Now, what's going to happen next? Let's talk about that. There's going to be an opposing brief filed by Donald Trump's side and about 6 or 7 other co-conspirators who have also appealed. There's going to be a briefing schedule that's going to be set by the clerk of the Court of Appeals. And then there's going to be potentially oral argument. There's going to be one more brief, by the prosecutors. They get the final say. And then there's going to be on this briefing schedule, potentially oral argument. Either that or the Court of Appeals without oral argument, but on the papers, is either going to grant this or deny it. If they deny it, it's another ability for Fani Willis to seek immediate appeal by permission to the Georgia Supreme Court. So she'll be busy litigating this thing at the Georgia Supreme Court. In the meantime, the underlying appeal of Donald Trump is actually the one that's stopped in its tracks, while Fani Willis fights over this procedural issue, which is very important. If she wins at the Court of Appeals level, based on oral argument, or she wins at the Georgia Supreme Court, then this appeal gets dismissed right now without any other further argument, and the case gets returned to Judge McAfee, and she stays on as the prosecutor. And this was a very smart, very well strategic, developed attack to the appeal. Yes, if she loses on this, she'll have to argue the merits of the appeal. But right now, this is a great shortcut. It makes perfect sense. I mean, it was staring her right in the face. She had to bring this motion. When you have a motion when you have an appeal like Donald Trump's that's so heavily dependent on a factual record that has to be accepted as true, you have to bring a motion like this. So kudos and chef's kiss, top of the hat, tip of the hat to Fani Willis and her appellate team in Fulton County. And we will follow all the developments related to this right here on the MeidasTouch Network, on this YouTube channel. Free subscribe, help the MeidasTouch YouTube channel get to 3 million free subscribers before the election day. And we'll continue to bring you stories like this and updates about this story on hot takes like this one. I'm Michael Popok. If you like what I'm doing, thumbs up and leave me a comment. And then on our leading top podcast, The Intersection of Law and Politics, something we call Legal AF, and now you know why. Join us on Wednesdays and Saturdays at 8 p.m. Eastern Time, right here on this YouTube channel, and then on audio podcast platforms of your choice. So until my next hot take, until my next Legal AF podcast, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.